Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God? Yes. Please spell your first and last name for the record, please. Stephen Bosniak.
All right, very good. You may inquire.
Thank you, Your Honor.
Welcome to the courtroom of Judge Simpson, where today's case takes us deep into the unsettling clash of memory, trauma, and justice. The witness you're about to hear from claims he was assaulted back in 2018 by the man sitting in court today, Larry Lee. But here's the twist. He didn't report it until 2024, 6 long years later. Why the delay? That's one of the key tensions you'll see unfold. In cases like these, credibility becomes the battlefield. The defense will argue his memory is unreliable, blurred by alcohol and time. The prosecution will push the raw emotion, the fear, and the consistency of his story. Notice how even the earliest questions, his name, where he lived, are meant to ground him in detail before the heavy accusations begin. As we go through this testimony, ask yourself, does his story hold steady under pressure, or does doubt creep in with each missing detail? Stick around, because this trial is about to expose contradictions, defenses, and a judge who doesn't flinch when it comes to weighing truth against time.
And I want to make sure I'm saying that last name right, because I think I've mispronounced it a few times. Is it Kwasny? Okay. Mr. Kwasny, could you please tell the court where you lived in 2018?
914 Julie.
Okay. As far as you know, is that city of Ann Arbor, state of Michigan, and Washtenaw County?
Yes.
Thank you. And in early, excuse me, 2024, around January, February, did you walk into Ann Arbor Police Department station to report a crime?
Yes.
Okay. And did that crime that you were reporting involve a Larry Lee?
Yes.
Do you see Mr. Lee in the courtroom today?
I do.
Could you please point him out, describe something he's wearing? Could you describe what he's wearing?
A jail outfit.
Thank you.
Hold on one moment, Ms. Tanner. The two people in the front row, you need to back up one row, both of you. Excuse me. Yes, you guys just need to back up one row. All right, just that first row needs to be empty. Thank you.
Your Honor, may the record reflect the victim identified the defendant, pointed him out in the courtroom at defense counsel's table.
That objection record shall so reflect.
Objection.
Here's a critical courtroom moment. Identification. The witness just pointed straight at the defendant, Larry Lee, seated at the defense table. Identification is one of the most powerful pieces of testimony because it ties the accusation to the man in the room. Defense counsel objects, not because the ID itself is shaky, but because they want to preserve the record, maybe for appeal. This is courtroom chess. Object even if you know you'll lose, so you can argue later. For the jury or the judge though, seeing the accuser point directly at the accused hits hard. It transforms an abstract allegation into a personal confrontation. This is no longer someone somewhere. This is that man, right there. What do you think? Does a confident in-court ID after years add strength, or does the long delay weaken its impact?
Thank you, Your Honor. And what you reported, where did that take place?
My home.
Okay. At that Dewey Street address you just mentioned? Okay. And can you please tell the court what you reported happened? When you say he, who are you referring to?
Larry.
Mr. Lee, defendant?
Yes.
Thank you. I'm sorry, I just have to be really clear for the record.
Yeah.
That's why I keep asking you questions. I'm going to ask you some questions about what happened and what you reported. When I'm done asking questions, defense counsel might ask you questions, okay? If you need either one of us to rephrase anything, please let us know, okay? And you said you reported something happened in 2018. Do you remember approximately when during that year it happened? Okay. And who was in your apartment when this crime happened?
Just Larry and I.
Okay. Can you tell us what had happened earlier in the evening? At what point did you get to your apartment?
So, I had people come over from after bars one night. Never met Larry before. He came with another friend that I don't remember who she was, but it was another girl. We had a drink at my place. He asked kindly to stay over because, well, started to leave. It was 10 in the night. He asked to stay over because he was too drunk to drive, so I let him stay over. And,
This is where tension builds. The witness describes Lee asking to stay over because he was too drunk to drive. On the surface, this seems like a reasonable favor. One friend helping another person in a risky situation. But legally, this is the setup moment. In criminal law, context matters. Allowing someone to stay under the assumption of safety creates a clear boundary of consent. He was supposed to stay on the couch. That detail will become critical, because the entire case hinges on whether Lee violated that boundary knowingly. Notice how the prosecutor carefully rephrases. Did he do anything concerning at that point? The goal is to lock in testimony that Lee appeared harmless, making the later intrusion more shocking. Would you have let him crash on the couch, or would alarm bells have rung sooner?
I want to just pause you there. So he asked to stay over because he had been drinking.
yes,
You let him stay over. At that point, had he done anything to make you feel like that would be a concern of yours for him
No.
to stay over? Okay. Good. Well, go ahead. What happened after you allowed him to stay over?
so I fall asleep. I wake up to him in my bed, fuck ass naked, stick out.
Okay. I'm going to go back a little bit and then we'll get to the details. Okay.
Of course,
Before you went to bed, you indicated he was staying at your place. Where was he supposed to be sleeping?
on the couch.
Okay. Before you went into your bedroom, was he on the couch?
Yes,
Okay. And had you indicated, excuse me, had you indicated to him that that's where he was going to be sleeping?
yes.
Do you remember approximately what time it was? Was it early, late?
6, 7.
Okay. And had everybody been at your house and kind of drinking and just spending time until then?
Yes,
So he's on the couch. You're going to bed at that point in your bedroom?
Yeah.
Thank you. Had you, can you describe just to the court very briefly the layout? So where's the living room in relation to the front door and where's your bedroom?
they're pretty close. It's not a very close.
So you went to your bedroom. Were you starting to get ready for bed or were you already in bed when Mr. Lee entered? And what's the first thing you noticed?
This is where the testimony crosses from background to raw impact. The witness describes falling asleep, only to wake up to a half-naked man in his bed. The courtroom hushes at moments like this because you can feel the shift. This isn't casual anymore. Legally, the details matter. Where was Lee supposed to be? On the couch. Where was he? In the bed. Pants down. These facts are not about memory blur. They're about direct observation in a shocking moment. The prosecutor presses for detail, not to embarrass the witness, but to paint a crystal clear picture of non-consent. And the defense will later seize on lighting, memory, even alcohol. But ask yourself, do you really need bright lights to know when someone is in your bed without permission?
His dick was out
Okay. Were you awake? How did you wake up before you saw that?
abruptly.
Okay. So you're sleeping in your bed, and I'm gonna ask you to be a little more detailed if you can. You're sleeping in your bed. What's the next thing that happens that you remember? And did that wake you up? His
Yes.
presence? Okay. And when you wake up and you open your eyes, what did you see?
Yeah.
Mr. Lee, is that who you're referring to?
Yes,
Okay. And if you remember, did he have any clothes on?
no.
No clothes on at all?
I mean, like the shirt was kind of off, his pants were down, like they were like around like his like knees or something.
Okay.
So,
Were you wearing any clothing in bed?
yes,
And so you wake up, you see Mr. Lee, and you said his penis was exposed.
yes.
Do you remember if he was doing anything with his penis?
And, like at that moment, I was kind of scared for my life.
The witness struggles here, his words faltering as he relives the event. Trauma often surfaces this way, fragmented, emotional, less polished. The prosecution knows jurors don't expect Hollywood-level clarity, they expect human reactions. The defense, though, will point to this very fuzziness as proof of unreliability. Here's the legal nuance. The law doesn't require perfect recall, it requires credible testimony. When the witness says it was the first time he ever met Lee, the shock of waking up to a stranger in such a position makes his fear more believable. And his emotional stumble may not weaken the case, it might strengthen it because it feels raw and real. Do you think breaking down in court shows weakness, or is it a sign of truth cutting through?
It's the first night I ever met him, and, it's not a fun situation to wake up to.
What happened next? So you wake up, you see Mr. Lee, his penis is out. What happened next?
I asked somebody to get the fuck out of my house.
Okay. Did Mr. Lee get closer to you or do anything to your body?
He was resisting.
Okay, can you tell the court a little bit more about that,
So he
please?
was trying to talk about pants, saying it'd be okay, you don't have to tell anyone. And then I just kept yelling, screaming. It was just waking up at the time.
So at this point, because you saw when you saw Mr. Lee, I want to go back a little bit. When you saw Mr. Lee, how far was he from your bed?
He was in my bed.
He was in your bed already. Okay. And then what's the next thing he did? You said he tugged at your pants?
Yeah.
Okay. As he's tugging at your pants, is that when you were telling him to get out and yelling?
Yes.
And what was he able to move your pants down?
This moment zeroes in on force and resistance, the heart of many assault cases. The witness confirms he fought back, that Lee tried to pull his pants but failed. From a legal lens, resistance is powerful evidence. It shows lack of consent in action, not just in words. But here's the twist. Defense attorneys will argue that because no full act occurred, maybe there was misunderstanding, or maybe it wasn't attempt in the legal sense. This is where statutes matter. Attempt doesn't mean success. It means intent plus action. And when Lee whispers, "It's okay, you don't have to tell anyone," that's damning. It signals knowledge of wrongdoing. Think about it. Why would an innocent guest say that while tugging at someone's pants?
No,
Were you fighting him?
of course.
Do you remember, or were you laying on your stomach, back, or side?
I'm on a stomach.
So as he's tugging at your pants, where on your body? I know this is, silly question because we know where pants are, but where on your body is he touching as he's pulling? When you screamed at him to get out of your apartment, did he leave right away? Did anything happen after he was tugging at your pants to pull them down?
No.
And you said he was saying some things to you.
Yeah. Just let it happen. It's okay. I want to tell anyone.
And what in your mind did you believe that to mean? Just let it happen. Let what happen?
Like, to try to sleep with me.
Was his penis out during all of
Yes.
this whole interaction? Did he eventually leave?
Eventually.
Do you remember approximately how long it took for him to leave?
5-10 minutes.
Can I have a moment, Your Honor?
Yes.
What was going through your mind as Mr. Lee was tugging at your pants with his penis out?
I was scared for my life.
Here we see the emotional core, fear. The witness says he thought he could be harmed, even killed. In court, fear is not just emotion, it establishes impact. Sexual assault statutes often require proof of coercion, force, or fear. His testimony checks that box directly. Defense will later argue about delays in reporting, but fear explains that too. Fear silences victims, especially when the assailant is unknown. Notice also how Judge Simpson steps in earlier to ask the witness not to curse. This is important. It shows the courtroom balancing raw trauma with formality, reminding the jury that emotion must be weighed alongside evidence. Viewers, let me ask you, if you were in his shoes, would you have run straight to the police, or would fear and shock keep you quiet?
Never met him before that night. Didn't know who he was. Just in my bed. Doing that. Never experienced anything like that in my life before.
What was going through your mind once he left your apartment?
How that could have happened? Because the situation goes from trying to do him a favor, no, not like trying to drunk or anything like that, to now he's ass fucking naked like that.
Can I ask you to try not to cuss in the courtroom? I know you're upset, but we're gonna try to be as polite as we can, okay? Did you think about reporting the incident?
I wish I would have. But no,
Can you tell Dakota a little bit about what was going through your head that you didn't at the time?
like, you usually don't talk about, like, if something like that happens, it's hard to talk about. It is.
I don't want you to go to any details, so just yes or no answer. Did you end up running into Mr. Lee later on in 2023?
Yes,
December of 2023, roughly?
yes,
Again, same thing. I don't want you to go into any details, just yes or no. Did you end up running into Mr. Lee sometime in January of 2024?
yes.
Without going into what you've said, have you talked to other people about this since 2018?
Absolutely.
And has that had an effect on how you feel or how you felt about reporting it?
Yes.
Okay. Again, without going into what anyone said, can you tell us a little bit more about that? Sure. Can you tell us kind of what your mindset was and why your mindset changed?
Once I learned that he's done this to others and it's continued paying for it, I mean, I started saying something.
This is a bombshell. The witness reveals he didn't come forward until learning Larry Lee allegedly harmed others. That admission shifts the case from an isolated claim to a possible pattern. Prosecutors love patterns. They show motive and opportunity beyond coincidence. The defense, however, will argue this is hearsay. Stories from others shouldn't shape his truth. Still, jurors hear this and think if multiple people said similar things, maybe there's fire under this smoke. Legally, the judge has to keep the focus on this incident, but emotionally, it's hard for anyone in the courtroom to ignore the implication of repeat behavior. Do you think a victim should need confirmation from others before stepping forward, or should one voice alone always be enough?
Because he has a long history of harming others.
No further questions at this point, Your Honor. Thank you.
Cross-examination.
Good morning. I'm just going to ask you a series of questions. If you could just sort of follow along and answer them as they come at you. This was an event that was reported to the police initially in 2024. And this was an event that occurred that you're testifying to back in 2018. And in 2018, you did not go to the police.
This is Defense Strategy 101. Highlight the delay. 6 years without reporting, that gap is their weapon. They want jurors to believe memory fades, details blur, and the whole story is suspect. But legally, delayed reporting is common in assault cases. Victims often fear shame, disbelief, or retaliation. Courts know this, which is why judges often allow explanations for delay. Here, the witness already said fear silenced him. The defense, though, drills into it, because if they can convince the court the memory is unreliable, reasonable doubt creeps in. Remember, in criminal trials, the burden isn't on the witness to prove clarity, it's on the prosecution to erase doubt. And every "why didn't you" question feeds that doubt.
In 2018, you testified that he came to your residence. That's correct. And do you know who he came with? How many people came to your house that evening?
Sports a little county.
Who were the other individuals?
Can't
Who did you, what, you said you were at a bar. What bar were you at?
What's important is.
No, I'm just,
Answer.
you could answer my questions.
You didn't come to us from the bar, you joined through.
Okay,
So.
fair enough.
So you were at a bar. Which bar were you at? And what day of the week was this? It wasn't during the week? You said a second ago, he came with somebody else. He didn't come directly from live. How did that other girl that we don't know to come over to your house?
She came with the other person. I was kind of fuzzy. It's like when you go through a traumatic experience like that, it's kind of.
Now, you just say, you just got to say what you remember. So this other girl had been in contact with you to come over to your house, or was it that other girl through somebody else? Okay, so and you said there were 4 total. Was that including you?
Yes.
Okay, so you invited one person. How many people did you actually invite over? And 4 came.
Notice what the defense is doing. They're pulling apart the party details. Who came first? Who came later? Who was even there? Why does this matter? Because credibility in assault cases often hangs on consistency. If the witness can't clearly say who entered his apartment, when and why, the defense argues he can't clearly say what happened in the bedroom either. It's all about planting doubt. But from a psychological lens, trauma impacts memory unevenly. Victims often recall the attack vividly, while smaller details blur. That doesn't mean the attack didn't happen. Still, for jurors, inconsistencies in minor details can snowball into big doubts. Question for you: would you expect a witness to remember every guest's name 6 years later, or does the main event matter more?
3 came. Did they all come in your apartment together? You know, if they separate times, who came first? And then who came second?
If like I knew where they were at, it has to be in this room for how many times we've been in this room.
Okay, so you just brought up another buddy. You said there were 4 people there. How many people were over there?
4.
Okay. So you said they came together, or they came at separate times?
They
Okay,
came together with another girl. I knew the girl's name. I remember the girl's name.
okay, so he comes with somebody else. When did somebody else come? Okay, is that something you remember, or you're just trying to put together today?
No, this is something I remember.
Okay. About what time did they come to your residence?
2:30 somewhere.
What was the intention of all these people coming to your house at 2:30 in the morning?
So
I'm gonna object, Tony. He can't speak to what their intention was. He can only speak to what he.
I'll sustain the objection. You need to rephrase your question.
Okay. You were invited people over. What did you plan on doing with all these people? Okay, was there alcohol involved?
Yeah.
Okay. Had you been drinking at the bar? Okay, about how much did you had to drink that evening? And what were you drinking? Okay. What time did you get to the bar that day? And you were there till close?
Yeah.
What time did they close? Don't close at 3 or 4? Close at 2? Okay. So how well do you, outside of this defendant, how well do you know the other 2 people that were with you?
The one girl, sure, whatever money was there.
Okay. How did you get home? Okay. Do you know how these other individuals that came, do you know the other individuals live?
No.
Did you ever know where this defendant lived?
Not close.
About what time did the other 2 individuals leave? Okay. Do you know if they left by, do you know what transportation they left in? Did they?
Some Uber, some drove. What's important is that he asked to stay.
Okay. Did you ask him where he lived? He is Basically, he's a stranger to you. So you said it was a small apartment?
Yes.
You guys were all sitting together? There was lots of conversation that evening, early morning?
Yeah.
Did you get to know him while you were there?
A little bit, but like just kind of listen to music and just hung out, you know, that was common for what I would do back then. But music, have people over most of the time. I know this would be the last time I ever let someone in my home. That I know.
He asked to stay. You said, why don't you take an Uber home?
He said he was too drunk to drive. He asked to sleep on the couch.
Here's a pivotal admission. Even the defense confirms the arrangement was for Lee to sleep on the couch. That means both sides agree on the boundary. From there, the case becomes about whether Lee knowingly violated that boundary by entering the bed. Defense tries to soften it. Maybe he was drunk, maybe confused, maybe misunderstood, but intent doesn't require sober perfection. It requires awareness of action. Climbing into someone's bed uninvited crosses a line no matter how many drinks you've had. And remember, the witness already testified. Lee said, "It's okay, don't tell anyone." That's intent. That's guilt. Defense is left juggling straws, while the jury is likely thinking, couch agreed, bed invaded. Case closed on consent.
You didn't say, can't you walk home?
Say those things before. Next to stay. When I'm sleep on the couch, I obviously I knew it was gonna happen. It was gonna happen. But in the house, I knew it was gonna happen.
And you said he was intoxicated? Did you watch him drink at your house?
Yes.
You know how many shots he had, or what were you drinking?
I can't remember exactly what he was drinking. It was either whiskey or tequila or vodka. Those are the kind of things I had in my house.
How much did you drink at the bar and how much did you drink in your house?
But I see where you're getting at with all this.
No, you just need to.
I had probably 4 or 5 drinks at the bar, probably 1 or 2 drinks at my house.
You say he woke up. Do you think that let me rephrase. After this evening, did you ever have any additional, did you ever hang out with the other 2 people outside of this person?
So anytime I would run into him, it was like over the course of the years, like I worked different marketing or event planning and roles in different bars. He was always addressed as a priority threat.
No, just strictly the other 2 people that were there. Did you ever run into them?
The girl, no, like her buddy, like probably, but I don't know. This is something I just can't recall.
You never told them what happened.
No.
You didn't go to the police the next day.
The defense hammers the silence again. No police call, no report, no action in 2018. But silence doesn't mean safety. Studies show most sexual assaults are never reported right away. Fear, shame, and disbelief play powerful roles. The witness himself admitted he wished he had reported sooner. That regret resonates with many jurors because it feels human. What's interesting here is how the defense frames the timeline. You didn't call at 4 a.m., you didn't call the next day. They're not just questioning memory, they're questioning character. The subtext, if you didn't act then, maybe you're acting now for other reasons. It's cold but effective. Viewers, ask yourself, if something traumatic happened to you, would you be ready to walk into a police station the next morning, or would fear stop you?
No.
You didn't call the police that evening. And this would have been about 4 or 5 in the morning.
This would have been later in the morning, like 6 or 7. Everyone left at 4 or 5. He stayed over. I fell asleep. I woke up to him fucking naked in my bed, sleeping like.
He didn't call the police. Did you? You said it took him 5 to 10 minutes to listen to you to leave.
Yeah.
You woke up and he was standing up.
He was in my bed. Right. You've been listening to this.
Does he, after you start screaming at him, does he stand up?
No.
Well, the question is, does he stand up at some point? I mean, he doesn't crawl out of there. Sometimes he stood up from the bed. Okay. So how many minutes were you screaming at him to get out of the bed? Took you 5 minutes to get him out of the bed? And when he stood up, how long between did it take him to leave? I could have a moment here.
Yes.
Did you have the TV on? Was there light in the room when it was dark? Okay, so it was pitch black.
Yeah, it was still light because the sun was up.
Okay, how many windows do you have in your room? Can you tell me what type of tattoos you saw on his body?
I just remember his dick and his long fucking hair.
When you say his hair, where was his hair? What you're describing it as blonde.
Yeah.
Well, what part of his body? Does he have any tattoos on throughout his body?
Now watch the defense change tactics. They pivot from timeline to physical description. Tattoos, hair color, lighting in the room. Why? Because if the witness can't confidently describe Lee's body in the dark, the defense can argue misidentification. This is tactical. They're trying to suggest the witness might have been mistaken, that maybe the memory is blurred. But ask yourself, do you need a tattoo checklist to know who was in your bed? Probably not. Still, these details can sway jurors. Precision equals credibility. Vagueness equals doubt. That's why defense lawyers love asking about tiny specifics. If the witness falters, they frame it as proof he could be wrong about the big picture.
He didn't have the facial tattoos they did today.
Okay, but on his torso, did he have any tattoos?
Can't recall. Recently, absolutely. Not all the time.
Thank you.
Can you redirect?
Just a few questions here. Thank you. Mr. Kwasny, you mentioned that this was just one of those situations where you were out, you were drinking, having fun, and then people came over to your house to hang out. That's something that at the time would happen frequently.
Yeah.
And was it a frequent occurrence to have their friends join and just kind of come to your place to hang out? After what Mr. Lee did to you, did things change?
Absolutely.
Okay, can you tell us a little bit about that?
So, one of the things to stop having people over as often. It's stuff kind of catches up with you kind of quick, you know, something like that happens. rethink your life. How you put yourself in those situations.
So would it be fair to say that what Mr. Lee did to you had an effect on your life and mindset? And how has it felt having to show up to court a few times and testifying today?
Well, at least we're speaking today.
Is it easy for you to talk about what has happened to you?
It gets easier as I have to talk about it more often, but it's not easy.
Thank you. Nothing further.
Anything else? You may step down. Thank you, sir. Call your next witness.
Your Honor, people don't have any other witnesses.
Any witnesses for the defense?
No, Your Honor.
Your Honor, a few things. First, I would motion for bind over on the count we have in the complaint currently. I would also motion to add count 2 of indecent exposure. That's under MCL 750-335A 2A.
335A.
Let's see, 335A. It's actually it's a 1-year misdemeanor and or $1,000 fine. So I just ask that follow along with the felony.
Lucas?
Argument?
Yes, as to the bind over.
As to the bind over, obviously, I know the court has the ability to weigh the credibility of this witness. This is an event that occurred 6 years prior to the day of the reporting. His testimony was a little bit fuzzy about who he was with. And the occurrence of having knowledge of this event would have been more clear in his mind, having somebody come to his house with another girl that was, he testified that was a friend. He can't recall who that friend was. And he doesn't recall who his other buddy was, but he would call them buddy and friend when he doesn't even know their name. I think that's an indication that along with the intoxication that he had been drinking since 9, had been drinking all the way up until 4, I think his memory might be a little bit fuzzy about the situation. I just don't think that there is enough question of fact that this actually occurred. So I'd ask the court to not bind over on.
Here comes the defense's closing pitch. They argue the memory is fuzzy, the witness is unnamed, the alcohol heavy, the story doubtful. This is the essence of reasonable doubt. They're not trying to prove innocence, they're trying to erode certainty. But Judge Simpson doesn't buy it. In his analysis, he highlights the vividness of the witness's recollection about the actual assault, how he screamed, how Lee resisted leaving, how specific words were spoken. Those visceral details outweigh fuzzy background. Simpson is clear, delayed reporting isn't uncommon in assault cases. Emotional reluctance to tell isn't weakness, it's reality. And when credibility is weighed, he finds the witness believable. The defense, despite sharp jabs, fails to shake the core truth.
Either counts 1 or counts 2.
I don't need argument. The court, in listening to Mr. Quasnick, I guess I deeply disagree with the defendant's or defense rendition of his memory. Those things that certainly are important to him or were important from that evening, he has very vivid memory of and gives a very visceral response when he's asked about it. As to, while it's certainly not relevant, I don't believe it's certainly something the defense may argue regarding the time. I also think Mr. Quasnick explained that in that it was not something that he wanted to discuss, and that as time went on and he was talking to other individuals, that's what led him to come forth. That is not uncommon, certainly in cases of sexual assault. So while those are arguments that the defense makes, I don't find them very persuasive. I do find his testimony as to what occurred that evening, or that evening into morning, I guess, to be very credible. I believe that told telling the court the absolute truth about what happened, and that he was screaming for Mr. Lee to get out of his bed, and that it took some time, and he's very specific as to certain comments that Mr. Lee made regarding that. So for those reasons, the court would find that the people have sustained their burden and would find the defendant over stand trial on the criminal sexual conduct degree with the added count of indecent exposure following. You're going to need a new information on this with the added count to that. So are you waiving presentation of that?
You would waive presentation, stand, you would ask for a free.
All right, defendant having waived formal reading, standing mute. As to both counts, court will enter a not guilty plea. Pretrial in this matter will be set for
October 7th at 1:30 with Judge Simpson.
October 7th, 2025, 1:30 before Judge Cuffey.
And there it is. Judge Simpson binds the case over for trial. He adds an additional indecent exposure count, ensuring the charges don't just vanish under defense pressure. This is a strong signal. The judge believes there's enough evidence for a jury to hear the full case. For the victim, it's validation. For the defendant, it's a looming trial. And for us watching, it's a reminder of how credibility, fear, and persistence shape justice. This courtroom wasn't about polished stories. It was about raw truth battling doubt. Professional wrap-up. The case of Larry Lee moves forward with charges of criminal sexual conduct and indecent exposure. The witnesses' delayed but emotional testimony carried the day, despite defense attempts to undercut it with memory gaps. Judge Simpson underscored that trauma's timeline doesn't follow courtroom calendars. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.